Okay, I think we can still say good morning and welcome to the legal session of GDPR. My name is Māris Ruķers and I will moderate this session and speak as well. So we will have some speakers and I think our session will end in evening, of course. We will have some breaks, but in our session the next break is 13:30. This is 1:30 p.m. Yes, and I also will speak myself as a first, and I think we will have a good discussion because many things are not clear in relation with GDPR and application. And there are some news. For example, Article 29 Working Party has issued a new guidelines about breach notification. About our speakers, yes. I think they will introduce themselves as far as I don't see all of them here. Some I see, but not all. As you already know from the program, we will speak about privacy and security, appropriate technical measures, privacy, breach notification, so data transfer to third countries, yes, and many other things. So I wish you a good session. I think we will enjoy it. And if you have some questions, I encourage you to ask questions after presentation, because maybe it's a better way to do, as far as we will have breaks and maybe you will go to other sessions as well, so you can ask right after. But you will need to speak in the mic, so this is obligatory. Obligatory thing in this session. Okay. As a first speaker, I would like to speak about GDPR supervision problems and some words about myself. I am in data protection field since 2000, year 2000. I have worked some time in first years in Data State Inspectorate also in Latvia. Since 2001 I teach data protection law in University of Latvia Faculty of Law, so this topic is still in university for students. And also I am very busy now with GDPR consultations for state and private organizations. So this is my background for data protection. Maybe my presentation will be a little bit general, but it maybe will show what we could understand from this regulation and what is going on in European Union with this data protection thing. First, I would like to say that GDPR are not only source of law in European Union. There is many other important articles, as for example, Treaty of Function of European Union. There is article about everybody has right to his or her data protection. We have Charter of Fundamental Rights of European Union. There are 2 separate articles. 7 is about everybody has a right to privacy, and the 8 is about data protection, and we will see the full article in next slide. Of course, judgments of European Court of Justice. So even if GDPR will be applicable, these judgments could still make part of all laws. And we have already many judgments that interprets the law and requirements. Actually, data protection regulation provides possibility, of course, that member state can adopt a law that limits some rights, or, for example, state organizations are processing data. So this also, the part of law is national laws. International agreements between EU member states and third countries may be important concerning data flow to third countries, if there is any, and some upcoming projects, for example, e-privacy regulation draft. We don't know when it will come out, but this is GDPR are not the last source of law we have. This is Article 8 about data protection in European Union, and in bold you see what does it mean. Everybody has the right to data protection of personal data. You see that such data must be processed fairly. This is important thing because it shows that this article provides that data are already here, and if the data are processed, then they must be processed fairly. Everyone has the right to access his or her data. Also some procedural aspect, and right to have it rectified if necessary, if they are not correct, and compliance with these rules shall be subject to control. So if we talk about data regulation applicability, we need to understand what will be supervised. What exactly some procedural requirements or some substantial requirements. And this is, I think, important to understand. What does it mean? Everybody has right to data protection. We will see it from, I think, from the next slides. Because, as I understand, there could be only 2 situations. You process personal data, or you process not. There can be not a situation between. And this means that very important is terms what means personal data and what means personal data processing. I think this is 2 key terms in all this story. So, if we talk about supervision, we may see what is wrong. And we could divide this problem in about 3 points. So wrong is not correct processing. You can get a fine. This is, for example, unfair processing, or you don't notify data breach, for example. The second is fines for refusal of specific processing. Actually, for example, data subject asks to issue a data copy. This means that if controller refuses to satisfy this request, then controller can be fined. And the third I see is fines for processing that is not allowed at all. So this means that processor or controller cannot process data, but the processing is going on. So if there is two only situations, you have data. If you have data, you process them. And if you don't have data, you don't process them. Then you understand what can be supervised and what fines you can get for. And therefore, I look on the article about these sanctions, and I show you this article not because you don't know how many millions every controller can receive from supervision institution, but this I show because I try to find out what is wrong processing or what is wrongdoing from the point of controller. If he processes data not adequate. And we see there is a reference to many articles, not all of them I put here, but you see what is wrong. This is not complying with privacy by design, not notifying data security or personal data breach, not designation of representative, problems with records of processing activities, processing security, risk assessment, prior consultation, and so on. So we can go to the conclusion that this is very procedural moment. So nobody asks here why you have data at all, but why you process data in not a good manner. So you don't comply some procedural problems. Of course, there is a second part of these problems, for example, also here, where you can get more fine, is about also some procedural moments. For example, principles relating to personal data processing. Actually, control need to demonstrate compliance. What does it mean? It does means that it is again some procedural aspect. I need to demonstrate compliance. So I do something to demonstrate, but the question is when we will come to the question, can I process data at all? Yes, I just show that I process something, I have procedures. So what will be supervised and what will be fined is more procedural moments than substantial. If we go here, there is some, let's say, maybe a little bit substantial from this is legal grounds for processing, consent of child. These are things that relates to what controller cannot do. So this is that part, yes. Controller cannot process data without legal ground. But there's also some legal grounds, as for example, legitimate interest, that is very relevant in some situations. One controller maybe can do this processing, other not, because of some other obstacles that don't give reason to this data processing. And personal data transfer to third countries without adequate level of protection can be also fined. And this is like a fine for processing that cannot go on. So if we go back to this previous slide, we see that controller can be fined for procedural problems, for specific refusal of some specific processing, and fines for processing that cannot go on. So, what we can conclude from this saying that this is that data protection law, especially in GDPR, are very procedural norms. So it is more problem that controller don't have some procedure that shows that he can process this data, and less is a question why you don't have this data at all. Because if we think, for example, how insurance company cannot have data, of course they have. So, but they can process data if they follow some rules. And these rules are procedural, and it leads us to the conclusion that data protection law is procedural as such. If we look, okay, if this data protection law is very procedural, then problem is how can we check this procedure, and what is necessary from controller. And there is a problem that many terms are with high level of abstraction. So, for example, appropriate technical and organizational requirements. Every controller needs to adopt and implement appropriate technical and organizational requirements. So, what is appropriate in this situation, and what is appropriate in this situation in this time, and what is appropriate next day or after half a year, maybe it is different. For example, high risk for data subject rights and freedoms. These are only some of examples. I didn't want to show each criteria that is very abstract here, but to show that there is a trend that in this GDPR are many terms that is rather abstract. So what is high risk for data subject today? What is high risk after half a year? And this leads also to conclusion that this regulation don't mean that we will implement it today and we will do nothing after all. This means that actually this regulation asks from the controller time to time, review the procedures, review the risks, review the other organizational things. And the question is, what is methodologically or what is the standards for this job? And we see that regulation actually don't adopt or don't give us a clear reference to some standards. So now we see that Article 29 Working Party tries to give some guidance how to do, for example, risk assessment for data subject rights and freedoms, and this doesn't mean that only privacy is here meant, because data subject has also other rights, not only privacy. So There is a problem, I think, with methodologically, and this can lead to the problem that in some countries some issues will be treated differently. For example, I think the first thing that every controller started to do is data processing activity register. You have heard about it, I think, yes? What does mean activity register? I try to understand, because what is mean by activity? So is it purpose of processing? Is it sub-purpose of processing? Or is it a real technical, for example, thing? For example, I have saw a Belgian interpretation about this activity register. They think that activity means actually purpose of processing. So, for example, Belgian inspection thinks that one purpose, one activity, so you have one activity register for one purpose. And even data, certain data fields are not necessary. You can show only data categories. So, what is, for example, our understanding in Latvia, or I have seen that many controllers do different. One controller thinks that activity is like also sub-purpose. Some controllers think that activity register is purpose. Data processing purpose means that you see that these interpretations are coming, but we don't know the clear methodology how to deal with this with these terms with high abstraction, or maybe not high, but not very clear. From what we can learn from all this, what did I say? I think that it is not possible now to avoid from data processing at all. So we live in a certain society that develops technologies. So I think you all have a mobile phone. Of course, you can say I will not use mobile phone because I can be tracked and so on, and I want my privacy. So I will not use internet bank. I will not go in internet to buy things. I just will live then where. So even in woods now also you can be tracked without your phone. There was an example that people think that if he is not registered in Facebook, he is very safe. But there is other example that it's not really so, because if you are not registered in Facebook, I can register in your place and be as you. So, and everybody will think that this is you, and maybe I somehow will steal your identity in social network. So it goes out that maybe it's better that you are in some social network, so nobody can make a copy of you in internet. This means that actually this society where we are living will process more and more data. So this is clear. And it's not possible to develop without it. So public law have to follow this problem, because if you all are in Facebook and you are dealing and buying things, then what is going on with taxes? So we have to check what is going on in internet also. So public law will change and follow this this society and also will process more and more data, or will process this data in different way than before. Actually nowadays personal data protection regulation is like a mediator between other rights of data subject, because if everything we do in internet, job applications, banking, insurance, and so on. This means that data regulation need to balance what data is necessary or fair, what amount of data, and what is not. So this situation leads to the thing I told before, that data protection regulation is very procedural. So the question is rather about data amount than about can we process the data at all. Of course, in some situations maybe it is a question, but these situations will be not very much. Okay, actually privacy right in general will be more and more limited. What is left for data subject then? I think it goes more and more that this right will be even more procedural, because also state institution, supervision institution cannot supervise everything. They cannot go to your office and understand, did you transfer data to third countries or not? Maybe they can understand something, but not all. So this means that they will ask procedures from you that shows that you process data fairly. And data subject also will have right to check whether it is so. But it is very doubtful that there will be many cases when data subject can delete data at all, because the problem with other legitimate grounds, for example, if you have a labor agreement, then you go for other employer. This agreement and this data of employee will still be in computers because of archive requirements, other requirements. So this data will be more and more processed, and the question is more about amount and procedure. And actually GDPR in general, this is my view, you can maybe correct or say after all some comments, but GDPR in general narrows down the subject right actually to, in general speaking, right to fair procedure. Yes, so if the procedure is fair, then in general it is okay. And of course, lack of any procedure, lack of any assessment, risk assessment could lead to conclusion of supervision institution that personal data is not processed legal because you don't have any procedure that shows that you can do something. So this is my introduction for our session. With general comment on what is, in my view, this regulation, how it will develop, and okay, maybe I can ask some questions if there is. No questions? You are confused? So, or maybe some comments. So then you know that actually supervision institutions will more ask from controllers really this all these accountability about procedures, requirements, implementation, and so.